Ms. Stone, do you anticipate calling any further witnesses?
I do not, Your Honor. We have.
No issues before we bring the jury back.
No, Your Honor.
All right. Mr. Keating?
No, Your Honor.
Mr. Larry?
I apologize, I was talking. You can, Ms. Stone can just repeat what she said, so I understand what she said.
I said that the state intends to rest, and we've confirmed that the clerk's exhibit list matches what the state was tracking for the exhibit list in terms of what's been offered, admitted, and what has not been admitted and not offered. Nothing is outstanding.
I did have the time to talk to my client. I don't need additional time if the court, I'm not sure about Mr. Kading, but I'm prepared to, that my client isn't going to testify. So if the court wants to do that as you described earlier, I'm fine, but I just wanted to forecast.
All right. Mr. Kading?
Hey, Your Honor, I took the 10 minutes to talk to him as well.
You did.
Okay.
All right. Then, I'm sorry?
You move on.
All right. So then I would like to go ahead and do a colloquy. I ask a few questions. I'm going to ask a few questions of Mr. Ali, and then I'm going to ask a few questions of Mrs. Ali. Mr. Ali, have you had time prior to today to talk to Mr. Kading about whether or not you will testify during the trial?
No.
Yes.
And did you have time to talk with him today again about whether or not you would testify during the trial?
No. Yes.
Oh, thank you. Do you understand that you have an absolute right to remain silent and not testify?
Yes.
And do you understand that you also have an absolute right to take the stand and testify on your own behalf?
Yes.
Mr. Kading indicated that you are choosing not to testify. Is that true?
Can you repeat the question?
Mr. Kading has indicated that you are choosing not to testify during the trial. Is that true?
No.
Okay.
لا أنا ما بدي السؤال بالضبط شو
I do not understand the question correctly. I can do the consecutive in this case.
Okay.
يعني شنو بالضبط هو ما جبرني نسوي شيء أنا من ذاتي ما أريد أحط شهادة.
Yeah, I don't want to take the stand, and he did not force me to take this decision.
Okay. And so Mr. Kading told me on your behalf that you are not going to testify.
No.
That's correct.
Okay. And so that's a true statement that Mr. Kading gave me, that you are choosing not to testify.
No.
Yes.
Okay. Has anyone promised you anything to get you to not testify?
No.
No.
Is anyone forcing you to not testify?
No.
No.
Thank you.
Shukran.
I find that Mr. Ali is knowingly, intelligently, and voluntarily choosing to not testify in this matter. And Mr. Larry.
Your Honor, I did have an opportunity to speak with my client previously last week about testifying, how it is entirely her decision. And she has confirmed for me today, and is prepared to tell you in open court that it's her decision to not testify in this case.
Mrs. Ali, Prior to today, have you had a chance to speak with Mr. Leary about whether you would testify during this trial?
Yes.
And today, have you had an opportunity to talk with Mr. Leary again about whether or not you will testify during the trial?
Yes.
Do you understand that you have an absolute right to remain silent?
Yes.
And that you also have an absolute right to take the stand and testify on your own behalf?
Yes.
Mr. Leary has indicated that you are choosing to not testify during the trial. Is what he said true?
Yes.
Has anyone promised you anything to get you to not testify?
No.
Is anyone forcing you to not testify?
No.
Thank you. I find that Mrs. Ali is knowingly, intelligently, and voluntarily choosing not to testify during the trial. Before we bring the jury back, I would like to talk about scheduling. We can address jury instructions tomorrow starting at 9. I would agree that there's not a possibility from my perspective that we will be able to address the jury instructions, get those jury instructions finalized, and have the lawyers give closing arguments tomorrow, even though it would be wonderful if we could do that. I don't think that that is realistic. And so I'll tell you what I'm proposing, and then I will hear your feedback. We do jury instructions tomorrow, and hopefully then I would be able to have court administration email you the final version of the instructions in the afternoon. That closing arguments would then be on Monday, starting at 9 a.m. I will have the bailiffs order lunch for the jury so that we can have part of the closing arguments, take like a half-hour break or so that the jury can eat lunch, maybe 45 minutes, we'll see. And then we will continue with the closing arguments. Ms. Stone, do you have an estimate as it relates to your initial closing argument?
I apologize, Jenna, I don't at this time. I anticipate putting that together, and I can send that roughly to defense counsel. I anticipate putting it together plainly over the weekend. I wanted to see where our jury instructions end up. I think, obviously I've done trial in front of this court before a number of times. I've in advance notified defense counsel, but I've not had trial with either of them before. My practice, I'll be doing closing. My practice is always to do slides. Most of those slides, obviously, jury instructions. And so I want to make sure that I have a good, clearly understand what our jury instructions are going to be as I'm preparing those. We have a number of jury instructions in this case because of the number of charges and because it's 2 defendants, and some of those charges obviously are different between the 2. So I anticipate it's going to be longer than I would say my average, about an hour. So I'm going to say maybe about 2 hours. I'm hoping to be less than that, and certainly if there's a point during that where we need to take a break, I might ask the court to do that depending on what's happening with the jurors. I am mindful of diminishing returns, so to speak, on closing, so I'm mindful of that, but I also want to make sure we get through all of the evidence. We've been here for a while, we've heard from a lot of people, and there's a lot of instructions to apply that evidence to.
All right, thank you. Mr. Kading, do you have an idea in general how long your closing will be? And by that I mean an hour, more than an hour. That's really what I'm...
I would say it's probably going to be a little bit more than an hour, but hopefully not more than 90 minutes.
Okay. Mr. Leary?
Ms. Zoe will attest, I'm horrible at forecasting this, but I would say an hour.
Okay.
My only request is that whatever happens, that we contain it to one day.
Oh, we will definitely contain it to one day, and by ordering lunch, it gives us a lot of flexibility to ensure that we can have all of the arguments and hopefully give them time to at least get started. All right, let's go ahead and bring the jury back in. Please be seated. Ms. Stone, you may call your next witness. Kading?
Your Honor, at this time, I would like a couple of motions.
All right. Members of the jury, I am going to have the bailiffs take you back to the jury room. Please be seated.
I apologize, Your Honor, I had to wait for them to rest officially. At this time, Your Honor, I'd move in Mr. Ali's case to dismiss count 3, which is unlawful imprisonment. The allegation against him is that he somehow restrained his daughter unlawfully, apparently. She was at the time a minor, he was her parent. There does not appear to be a basis in law for the count of unlawful imprisonment. And for that reason, I would ask the case to be dismissed at this time. Similarly, on the assault in the first degree, the requirement is that there has to be an intent to commit a serious bodily injury, and in this case, excuse my language, I was looking for a charging document, but if I could have just 1 second, I'm looking at the, I thought I had it from me, but it was actually not it. The language on the charging document for the assault first degree
I can read it, I have it in front of me.
You have it in front of you, Your Honor.
Count 2 says, on or about October 18, 2024, as principal or as an accomplice, did assault another person, FIA, that the assault was committed by a force or means likely to inflict great bodily harm or death, and that the defendant acted with intent to inflict bodily harm.
Right, and in this case, great bodily harm or death, the intent to inflict that is shown by the evidence that we have here. What we had was a strangulation case, which is defined obviously differently. And so if the state's language is to be taken in general, any strangulation case would become a assault 1, and clearly is not. There's a specific assault 2 charge here that they did not charge with strangulation, and they didn't show any other intent to do anything other than strangle. No intent to cause bodily injury that would permanently affect any bodily function or disfigure or otherwise. So for that reason, I move to dismiss count 2 as well.
Thank you. Ms. Stone, are you going to address these arguments?
I am, Your Honor.
All right.
Your Honor, first of all, you don't get to restrain your child, anyone, let alone whether they're your child or they're an adult, by choking them into unconsciousness. You just don't. You don't get to restrain a person for that purpose. So that is an inaccurate statement that just because he's her dad, he gets to restrain her as a minor in whatever way he wants and for whatever purpose. So in terms of the unlawful imprisonment, the facts have been established and the testimony has been provided for a prima facie case for that, to defeat that argument. As it relates to assault in the first degree, again, a prima facie case has been established for that. I don't have the case directly on hand. Certainly I wasn't aware, and counsel doesn't have to tell me, but there is a case directly on point that says you can, in fact, commit assault in the first degree by strangling someone. Assault is, strangulation is not merely an assault to conviction, which appears to be the argument that counsel is making. In fact, in the case that I'm thinking of, like I said, I'll need a minute to go back and find it for the court, but the case that I'm thinking of, that is exactly the argument that defense made, in that it couldn't be an assault 1 because there's a strangulation prong specific for assault 2, and the reviewing court said that's not the case. It can also be an assault 2 by strangulation, but certainly strangulation can rise to the level of assault 1, whether it is completed or it is done with the force intended for great bodily harm. That the state doesn't even need to prove great bodily harm occurred, simply that that was the intent and the force used was done for that purpose. So the prima facie case for assault in the first degree absolutely has been demonstrated for this jury, and that is a question of fact for the jury to decide. I would ask the court to deny those motions.
All right. I want to get something out of my chambers, and so the good time to do that, so that also Ms. Stone, so that the record can be complete and I can look at what you are referring to. I will take, do you need more than 5 minutes? I don't need more than 5 minutes to get what I need out of my chambers.
Your Honor, my Lexus is still loading.
Okay, so as soon as you have the case and are able to also provide that site to counsel, let my clerk know and she'll call me and I will come in.
Yes, Your Honor, thank you.
Thank you.
All rise, court's in recess.